Yes.
Lordship, please.
Yes. Thank you, sir.
Lordship, I would like to mention a matter. It's bail in connection with appeal.
May I point of mention one matter that is specially assigned to a lordship. This matter was assigned to a lordship by my junior. The lordship directed the matter to appear as to be mentioned for succession of date. But this has not appeared.
We will.
Let it appear to be mentioned next Friday, my lord.
Next.
My lord, may I have a leave to prefer an appeal without certified copy? This appeal is under section 19 of
Server
Contempt.
copy is there?
my lord. Yes, my lord. I have a server copy. দুটো appeal.
Relaxation of condition of
আমি কি স্ট্যাম্প পাঞ্চ করে আনবো? আমার 5 মিনিট টাইম দিন।
relaxation of condition of anticipated.
Lordship, on the last occasion, 21st February, I mentioned the matter, Lordship, for correction, Lordship. The matter was not in the list.
My lord, may I pray, my lord, for inclusion of a specially assigned matter? My lord, only one thing, my lord, we had mentioned this also last week. My lord, there's some urgency in the matter. My lord had heard Mr. Shobhoshaji Chaudhary at length in this matter related to unauthorized construction. The building unauthorizedly constructed, my lord, for about 5 years. My clients are only, my lord, residents at that property.
Listen, next Friday
lordship.
there is a difficulty because we have fixed some other matter next Friday.
My lord, any day convenient to, my lord, will
Friday
kindly. Yes, my lord. It was also returnable on 7th, but my lord, any day convenient to, my lord, will
Friday.
kindly. Deeply obliged, my lord.
Lordship, may I be permitted to mention one matter? This is criminal appeal for non-prosecution.
Yes. No. Call the list.
On your side matter.
Well, I'm for the
Item number 1.
well, I'm for the petitioner. Lordship can remember of this matter that the entire structure over the first floor was to be demolished. The report was not correct. That is the reason he obviously perused the thing and submitted the report. Now, Lordship directed the BE College Manager to submit a report before Lordship's court.
Yes.
Now there are 2 copies here in the same envelope. Kindly excuse me, Lord. Report. One for your lordship, one for honorable justice. Yes, for
Ah. The report says there is no demolition done.
No demolition. That is I'm submitting. No demolition has been effective.
Then how did your officers give a report that the demolition was done?
But we have filed a let me have a copy of the.
You get the copy, Mr. Mukherjee. Please make a photocopy and supply it to the alleged contempt.
your lordship direct. Unless your lordship direct, I cannot.
Yes, we are directing.
Only one thing, my lord. So far as my officers have done demolition, that is not habitable. That has been written, and in the report, perhaps it can be written that not habitable.
Habitable, non-habitable is not the issue, Lordship.
Sir, there was a clear direction that
Yes.
if a report
In
has
the
to
meantime,
demolish, sir.
only a liberty,
entire.
only liberty may be given. The entire demolition may be
Liberty
done
had
in the
been-
meantime.
with
First,
jail.
you will be sent to jail.
But only liberty may be given.
Yes, liberty will
what
be
is the
given.
liberty? Rejection is there.
All these things will be the first done, but first you explain your conduct as a wrong report given by you.
Should I serve to all?
Yes. Report. This is report by the Mr. A. Mukherjee. Is a report by the
Director. Can you have your-
director.
Yes.
He is described as director.
Yes.
IIEST.
He authorized civil engineer.
That
to-
we have seen.
Yes.
Direct report of director IIEST is placed on record. Copy of the report be circulated amongst appearing parties, including alleged contemners.
Yes,
Alleged
Your Honor.
contemners are permitted to submit their response to the report. Matter will appear 2 weeks hence.
My lord.
Please give
Should I
your
appear
report.
after 2 weeks?
2 weeks.
Should I appear?
तुम्हारा पेयर correct है.
Not really, not really. If we need the director's assistance, we will again pass orders.
Right.
For you, it is not necessary to appear because you are not a party. You are just aiding the court with intimation. Mr. A.
Right.
Ghosh, please go through this.
Hello, I'll give to you and
This
responsible
report is
proper
really
responsibility make
again,
it
Mr. Consider, we have nothing against your officers, but we have to work on the basis of their reports. If their reports are so much at variance with the report of the director IIEST, just tell us, is it not an obstruction to the administration of justice? This is what we are asking you as an officer of the court. Forget about everything. You are continuously representing the municipal corporation. If your officers are not giving you correct report, first person who is deceived is you, because you speak for them. Then we are misled. This is where our issue comes for the rules of contempt. Second comes as a corollary that it must be immediately done as a part of the purging of the contempt. First, purge the contempt, that they should be demolished. Secondly, give an answer. In your response, please do that. That we have purged the contempt. If you do that,
Yes.
we will take a more lenient.
Yes.
If you don't, and you take an obstinate stance, no, we were saying habitable, we are saying inhabitable. All these things with Mr.
Just close our
We
hands.
will make it very clear. We are not taking it in the right spirit. We rely on your officers. We respect them as public servants. And we expect that standard of objectivity in their work. He shouldn't be swayed by whatever we don't know. But when the director has given a report, if you feel this report is wrong, you tell us. But if it is not, then please purge your contempt. Say that already demolished or we have done this. We will take the rule on in a different manner.
Now
No,
it will
only
be
one
not.
thing I'm praying. If they take any exception, they are entitled. But kindly direct them to serve me a copy so that I can.
Please understand, first let them take exception. We have said you need not be concerned. First, our area is to implement the orders. Secondly, to purge them of an apparent contempt in light of your report. Since there is a case of contempt, prima facie made out now, we should give them an opportunity to respond to your report. Right. So we keep it after 2 weeks. In the meantime, we have indicated to you, Mr. Chair. Please put it in the minds of your officers. If you find that there is no scope to deviate from this report,
hands and we will
immediately purge your contempt. We will take a different
only
view.
one thing.
Failing which, we will be harsh.
Case of 2 weeks, either 4 weeks may be given because
2 weeks, 2 weeks. Mr.
We will complete our demolition by then.
You begin it. You begin it. We show your bona fides, sir.
My lord.
Show your bona fides. We will also come across in a favorable way.
I have followed you.
Yes.
একটা কপি দাও
এই কপি নিয়েছি আমরা নিয়েছি
তোমার কাছে এক্সট্রা কপি নেই
দুজন তো না ঠিক আছে এটা সব ভালো
ও দিয়ে তোমার কাছে ডাইরেক্ট নিলাম এই তো
Huh?
Lordship.
for the petitioner.
Well,
My lord,
I
on
am
the
praying
last
for
occasion,
not to
state
be.
prayed for an adjournment.
I have.
Day before
My lord,
yesterday
I have
also
been-
they prayed for an adjournment.
Yes, my lord, I am renewing. I am now praying, my lord. I think this cannot be a solitary case, my lord.
Fine, I also feel that way. I also feel that. Please ask your CID.
Lordship, it has to go to CID, but let me assess the situation, my lord. This cannot be a solitary.
My lord, this is a counterblast to my case, my lord. The de facto complainant Robi Lochon Pan, my lord, he induced me, my lord, to part with 3 lakhs, saying, my lord, I have a business of, my lord, tractor spare parts. He said that I will get you more business from Guwahati.
Let us see whether you have any
If it is a
criminal.
solitary case,
Lordship, just give this,
yes, my lord.
that petitioner submits that the dispute is civil in nature and has been given a criminal profile. Learned public prosecutor seeks adjournment to submit report with regard to criminal antecedents of the petitioner.
My lord, can there be an interim protection in the meanwhile, my lord?
They are not inclined to arrest.
Okay.
Obliged.
When should we keep it?
Monday,
Tuesday?
Tuesday, my lord.
Tuesday,
Tuesday.
better.
Tuesday. Deep blue.
Children, my lord.
Tuesday. Tuesday,
Yes.
chapter.
8:06.
গরম লাগছে না?
I'm first. Doctor, petitioner was placed on no Chatterjee in the petition.
Arnab Chatterjee is the petitioner. They beat up electricity people.
Yes, yes. Sir.
Ah.
And he, the petitioner is a habitual offender.
How many cases against?
One case is pending and evidence is started.
Ah, we have considered the materials on record. Petitioner has criminal antecedent. He assaulted. Yes, madam. You assaulted.
Lordship, there was a dispute regarding the connection.
Sit down.
Electricity.
Get your breath. Sit down and get your breath. Thereafter,
Lordship.
we have got the case diary. Let us see. Where's
There
the
was a,
injury? Where is
Lordship, the
injury?
petitioner has deposited the entire amount.
Deposit will not do here.
But Lordship, as per my instruction, there was only hot exchange of words.
Hot exchange of words. Let us see what has the hot exchange done. Physical assault by Tawfiq. At 2 pen.
Six. And 302
What is the injury?
Lordship, this is not readable, but
They get the readable what this is.
IU is not read.
Huh?
IU is not. IU is.
What does this mean? Grievous injury.
Some fracture is there, Lordship.
Fracture is there. Where is the fracture?
I have some.
Please ask the IO. Please ask.
IU is not readable, not legible.
IO is not traceable.
No, IU is not able to read it.
So ask the doctor.
Yes, I asked one doctor surgeon. He said this is the term is fracture.
So what is the term? Tell us what is the term. Monday. Monday.
Grateful, Lordship.
We cannot, let us say an illegible report. You say it is fracture. But you cannot read or tell us what is the term. How should we rely on that? If it is a fracture, surrender. Payment of dues will not do. Some electricity officer goes to disconnect, you break his bone.
Lordship, there was only
What is
hot
this?
exchange of words.
Huh?
There was only some hot exchange of
Hot exchange cannot result in break of bones.
He is hooking the electricity.
If you have that capacity, you will become, you will be in the Guinness Book of World Records. That by words I can break bones.
And Lordship, he is a habitual offender.
We know people who could sing and bring rain. But we are seeing your client breaking bones with words. Tomorrow, Monday.
Grateful, Lordship.
I am for the petitioner, Lordship. Counter case between the parties, Lordship.
We have considered the materials on record. There was a free fight between parties. Case and counter case was registered. Injury though on the head is simple. Accordingly, we are inclined to grant answer.
I'm for the petitioner. My lord, Mr. Kalidasar is appearing for this matter. His mother is ill. He is not available today.
Okay.
Praying for not today.
Okay.
Lordship, one thing is co-accused was enlarged on anticipated
We have
by this
considered
honorable
the
court, but
materials
there
on
is
record.
fracture injury, Lordship. There is the fracture.
Ah.
Fracture, coracoid process of left.
My lord, another co-accused person, Kuddus Sheikh, granted anticipatory bail. Kindly come to
Kuddus
page
has
number 9.
granted. We have considered the materials on record.
That is true, but there is
Co-accused Kuddus Sheikh has been granted
Standing on same
anticipatory
footing.
bail, though injury is grievous and has resulted in a fracture, comma, we note incident of
multiple injury, head trauma with multiple injury.
grievous. We note that the incident occurred on the spur of the moment and was not a premeditated one. Under such circumstances, we are inclined to grant answer.
Nine.
Lordship, I'm for the petitioner. Lordship, the present petitioner was having a relationship with one boy and that boy committed suicide, Lordship, on refusal of marriage. Lordship, the mother of the present petitioner was granted anticipatory bail by this honorable court.
One died was seized, Lordship, and some suicide note.
We have seen the suicide note.
31,
Petitioner submit that there was a romantic association between the petitioner and the deceased. Subsequently, it did not result in marriage. Deceased committed suicide. Ingredients of offense punishable under 108 of BNS are not disclosed. Accordingly, she prays for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the
31, 30.
We have considered the materials on record, including the suicide note. The note records there was an intimate association between the petitioner and the deceased. It also states that petitioner had physical relationship with other men. uh, uh, other men for out of the as a result, the victim felt depressed and committed suicide. Whether whether the conduct of the petition in having multiple relations would constitute abetment to suicide. No doubt, no doubt. Now, even if one believes the contents of the suicide note, it discloses that petitioner was not truthful to her relationship with the victim. Even if it is admitted that she had multiple relations, whether such conduct per se would amount to abetment to suicide requires to be assessed at the appropriate stage of the proceeding. Custodial interrogation for progress of investigation is not necessary and petitioner may be granted answer.
Grateful.
Next.
Lordship, for this state.
107, 379 on parity. Your Lordship, kindly see annexure P2, page 11. No injury, nobody suffered injury.
Yes, Lordship, there is no injury report, but he is been named by the co-accused.
All right, we have considered the materials on record. It is alleged that the accused had thrown bombs. However, no one was injured. Complicity of petitioner has transpired from statement of co-accused before police. Under such circumstances, we are inclined.
Deep level.
Next.
Thank you, ma'am.
Sir,
Please, Malad. The first petitioner is the senior branch manager. The second petitioner is the deputy manager of Punjab National Bank. Malad, the de facto is a retired colonel. The allegation is of Malad theft from the bank locker. Now, Malad, the locker was opened in 1997. On 17th March 2023, when he wanted to open the locker from his key, it could not be opened. Then on 21st March 2023, it was broken open, my lord. Then allegedly, my lord, jewelries which were stored therein, my lord, were found missing. Then the complaint was filed after 2 days, my lord, against unknown persons. My lord, the date of FIR is 23rd of March 2023 under 406-120B against unknown persons.
But locker property is not entrusted to the bank.
The bailment, my lord.
Lordship, at the property is not entrusted to bank. That is why the key, which is why you have physical dominion over the
Lordship, two keys are there. One key with the customer, one
But
key
it
with the
can-
bank.
the
Lordship.
bank cannot open it. Can the bank open it with the without the
With
consent?
two,
With the-
two keys.
Sir, it can only be opened jointly.
But in the key and the lock and the key, both were mismatched. When complainant went to open that,
Right.
lock was changed.
No,
Was changed.
102 টা দেখো,
Mismatched.
page 100.
It has
Good
to
for
be
the
broke
state.
open.
It is 102, nothing of that sort.
But this is a report by the maker, company, the maker of the locker.
Huh.
My lord will see that the report suggests that the key that was entrusted with the customer does not match with the lever of the key, the locker, which suggests that, my lord, there was some tampering with the locker, because that was the key which was previously used
Just
by
never
the
say.
bank
We have the
to
report.
operate the very
We have the report, page 102.
With the locker.
My lord.
It has been changed, Lordship. Without the help of the bank officials, it could not be changed.
But we don't understand this. There are two locks, two keys. Now, the lock, according to you, the lock was changed.
That is what the report suggests. The key does not match with the lever of the lock. Because the de facto says that previously I had
It has been
operated
seized from
that
the de
very
facto.
account, that very locker with that very key. But subsequently, when he tried to operate the locker with that key, he failed to do so. Thereafter, it was broken open and it was found.
Was the locker changed? With
No.
how will the locker be
Lock of the
changed?
loss.
How the lock will be changed? He may not have had got the right key. That does not give an impression that the lock has been
The
changed.
mechanic-
Until and unless you give a report that the lock was broken or had been replaced, just because his key does not match, does not mean that the lock has been broken.
So mechanic could not open. Later mechanic came from the Godrej. They couldn't open. Then it
So
has to
we
be
need
broken.
a better report. Who opened the locker?
And we have
Well,
complaints
the
to follow.
technician, one of the technician that the bank had called.
How the lock? Our query is this: has the lock been replaced? If the lock is replaced, they have a duty to answer. If the lock is not replaced, just because his key does not match with the lock, it does not amount to a replacement of the locker. He may have brought a different key.
I have a personal experience in this. So I had two lockers with the same key number. Unless until you prove that,
The lock is broken. The key not matching may not always give an inference that the lock is tampered with. It will give an inference that his key is not the key of the locker. That's all.
Sorry.
1 week. Petitioners shall not be arrested for 2 weeks or until further orders, whichever. is-
Complaints to
One mistake. Sometimes what happens is you have 2 or 3 lockers. Okay. Maybe bank A, you have 1 locker, bank B, you have 1 locker. You may have even 1 locker in two in the same branch. Now there's these keys. By mistake, you will take A key for B locker. It's not going to open.
But the
It's
key
not
with
going
the
to
bank
open.
that was also not couldn't open the.
He wanted better analysis whether the lock itself was tampered or not. If the lock is tampered, then what happens is they cannot also open it with their key. They would require a different key. How can they open it with their key? What happens? The lock is it's a twin lock. So key A opens, key B opens, the entire lock opens. Now key A is opening the lock. Key B is not opening the lock. The problem is with the key, not with the lock. You understand? Let them get their clarification.
But they have issued 41A recently, my lord. Can I comply with that in the meantime?
Petitioners will cooperate with investigate. That will help you. No? Close nexus with police is always beneficial for their case. Petitioner shall cooperate with investigation. Subject to such cooperation, they shall not be arrested.
Most
Grateful.
Sorry, but
This is a
My lord, I beg to appear on the petitioner, my lord, item number 13, my lord. My lord,
Yes.
apparently, the petitioner and the de facto complainant of the relatives dispute regarding a boundary wall that the petitioner number 2 has pushed the victim, my lord, admittedly because he tried to outweigh the modesty of the petitioner number 2. According
there was a fight between family members. Injury report does not disclose grievous injury. Under such circumstances, we are inclined to grant it.
I'm grateful, madam.
Next.
14.
Lordship, the 118.2 and 109 of the BNS, out of 3 FIR accused person, 2 already got anticipatory bail from the learned court below. 1 has been rejected.
This is the
Now, this is the altercation between 2 neighbors.
We have considered the materials on record. Though co-accused have been granted and suitary bail by the learned sessions judge. Though injury report shows injury is on a vital part of the body, that is scalp. However, it is not grievous. Accordingly, we are inclined to grant it. Next.
I don't know 15 beg to appear on behalf of the petitioner.
My lord, I am appearing for the state, my lord.
My lord, the dispute cropped up between 2 communal groups, my lord, for allegedly displaying of some insensitive remarks about some particular section, my lord, through a LED show. My lord, that same date, my lord, the de facto complainant accompanied by one Raju Sheikh and Sural Ali Sheikh, when returning home, it is alleged that they were assaulted by the petitioner, my lord. Firstly, the case was started, my lord, the grievous section, and secondly is the added section.
109, 196 to 196, 290. 299. 299 is 225. 299. The spreading enmity between groups. Malicious acts or religious feelings. Injury?
My lord, kindly peruse the page number 30, 31, 35.
Surrender. Petitioners submit that there was a dispute amongst two groups. They have been falsely implicated. They pray for and suitable and a lawyer for the state opposes the prayer. We have considered the materials on record. Statement of witnesses show that petitioners raised slogans and abused the complainant and his party, outraging their religious sentiments. Thereafter, upon protested, they physically assaulted them, resulting in grievous injuries. In view of the aforesaid circumstances, we are of the opinion, though custodial interrogation may not be necessary, movement of the petitioner requires to be regulated in order to prevent commission of similar offences. Stay outside Beldang.
Charge sheet has not been submitted.
Outside Beldang. Otherwise, again, they will create tension.
Grateful, lordship.
So,
P5 80 and 3/5 BNS. Husband is in custody. I am the mother-in-law. She committed suicide. After 4 years of marriage, she committed suicide by hanging. Mother-in-law is a 75-year-old lady. She is completely bedridden.
75 septuagenarian. It is alleged she has been falsely implicated. He prays for anticipatory bail and a lawyer for the state opposes the prayer. We have considered the materials on record. State allegations of torture are general and omnibus. Principal accused, that is husband, is in custody. In this backdrop, we are of the opinion custodial interrogation for progress of investigation is not necessary. And investigation is complete. Accordingly, we are inclined to grant. Next.
17. Okay, I'm a bit on behalf of the petitioner, your lordships. The principal accused is on bail, your lordships, space 3013, your lordships. So I'm the father of the principal accused, your lordships. Allegation against 326
the materials on
and
record.
307, your lordships.
Co-accused has been granted anticipatory bail. Petitioners.
No. Is in bail, your lordships. Space 13, your lordships.
So you will also get bail.
So I'm the father, your lordships. Kindly see my
You are not the principal accused.
No.
Acha, we have considered the materials on record. Principal accused has been granted regular bail. Petitioner is the father of the principal accused. Keeping in mind the extent of his complicity in the crime, we are inclined to grant answer.
I'm grateful, your lordship.
Not answer the petitioner, Lord. 338, 336, 340, 318, 335, and section 3.5 of the BNS, which is akin to 467, 460. It was alleged the de facto complainant is the brother and Lord, the brother-in-law of the petitioners. Lord, we have purchased the deed, Lord, on commission, and he has received the money through check. Lord, these are the deeds, Lord, but subsequently brother has turned around and said that he has not executed the deed.
Oh, you are co-owners.
Yes, brother and as well as co-owners.
My lord, I am the
For co-owners, you have sold a property.
They have sold the property to us, de facto. That's the deed.
You have sold they have sold a property to you. Now they are saying that they have not sold, but they have received money.
Money in check. Your lordship would kindly see the schedule.
My lord, I am appearing for the de facto complainant. My lord, the dispute between land belongs to me, my lord. My lord, kindly peruse the signature of both the forged deed and my lord, my signature. Kindly verify my signature is totally different, my lord. And my brother case,
Unidentified.
my brother and my brother sister-in-law are totally forged my fingerprint and my signature.
The accused is your brother.
Yes, my lord.
You are sister of accused.
No, my lord.
No.
Two brothers.
Two brothers.
Brother and my lord, the wife of the brother has acquired the property
Sister-in-law.
from him.
So you are the brother
Purchaser.
and the wife of the brother, and
He's another brother.
is another brother.
Yes, my lord.
As brother's property has been transferred to you.
By two registered deeds. Son identifies it, the son of the de facto complainant. Your lordship would kindly turn the next page.
Let it be investigated. So petitioner submit that.
Your lordship would kindly see.
Petitioner submits that they have.
My lord, they have not received the money.
Check, my lord, I have given.
Not received the money.
Yes, it, the
Lord, may I just show, my lord?
No, my lord. There's just a declaration.
There is a check.
I'll show, my lord, the check numbers from the deed I have given, my lord.
Where are the
And my lord,
they are giving check numbers. Please see whether the checks were presented.
The memorandum of the lord consideration. Your lordship would kindly see. Lord, I'll just show.
Show from your bank account that those checks were.
Yes, my lord.
Lordship would kindly give me, lord, 2
Yes,
days
my
time
lord.
so that I can bring it.
We are giving you time. Petitioner submit that de facto complainant had transferred the property against valuable consideration. Consideration sum was paid through account paid checks. Learned lawyer for state and de facto complainant denied this fact. Petitioner shall appear before the investigating agency and satisfy the agency that satisfy the investigating officer that the checks that consideration sum was paid through the account pay checks. Matter will
My lord, specimen for the handwriting.
that will come later on. If they have paid money, received money, then specimen we will give. Subject to the aforesaid, they shall not be arrested for 2 weeks or until further orders. Matter will appear 1 week.
Obliged.
Grateful, lordship.
Now you are checked. Bank statement থাকবে না? আমার একটা আছে। আমারটা পেয়েছো? 18
Thank you. Grateful.
What?
Has not come due to his personal difficulties and
Ah.
praying for not to do.
We have no personal difficulty, so we are taking up the matter. 16,190. Criminal breach of trust.
But he is the main, the employees, 5 employees have been arrested.
Hmm.
He is the kingpin. He is
What
the
is the
director of.
allegation?
My allegation is that, my lord, he used to call persons claiming, first of all, my lord, the employees say that he claimed to be an advocate. Thereafter, he started this, and under his instruction, my lord, he impersonated themselves to be representatives of reputed mobile service providers like Jio and BSNL, and my lord asked the customers to hand over money. Now, my lord,
For what?
my lord, for installation of towers.
Find out criminal antecedent. State shall submit
My lord, very
report.
recent stage of investigation.
Criminal antecedent.
So far,
CID. We are directing transfer to CID. In view of the nature of accusation, the case be transferred to CID. Criminal antecedents of the petitioner be submitted Wednesday.
Great.
Please, we've said to the public prosecutor, any mobile tower, any allegation of inviting money for various work like giving employment, providing services, the local station should immediately report the matter to CID. These are all cyber frauds. Next.
My lord, item number 21, praying for a short Passover, my lord.
No Passover. You are
This is
wonderful as a lawyer.
My lord, I am led by Mr. Rameshwar Sinha.
Geo Tower.
Not that good. Geo Tower.
My lord had rejected the co-accused anticipatory bid.
Tomorrow. Transferred to CID.
My lord, it's CID, isn't it?
CID. All right. Tomorrow.
Monday.
Mr. Public Prosecutor, can you give a request to all local police stations? Whenever tower in any cheating on the score of setting up towers or similar facilities, matter should be immediately reported.
At least report
to CID. Like the same thing as the NIA Act. NIA,
whether they takes it up or not, it's their matter.
What we are saying is, if like NIA, like under the NIA Act, whenever the scheduled offense is reported, the DG will give a report to the NIA. They may take it up or
may not take it.
May not. So, if you can give that will create a sort of nodal control. You understand how rampant these things are.
It will be done by the next
cyber
week.
arrests are also taking place
It
everywhere.
will be done by the next week.
Please do it.
Manner with the cyber notification.
Huh?
Cyber notification.
Yes.
My prayer.
No, we talk.
No, I have given a clarification also.
Because the
that
rules.
Your Lordship, Rickshawala, he has taken 5,000 rupees.
No, we understand. We understand. But the rules.
We have given clarification and given.
My registry came and met me.
Further representation.
Just they were about to give a direction. Then
we have made a further. We had a.
You have made a further representation.
We had a detailed discussion with the then Registrar General.
Now the
then we have
Registrar
given.
General has changed.
Yes, that's right.
I will take it up with the present Registrar General and get it done.
Lordship.
Thank you.
Great.
Twenty-two. 2.
$21.
I'm for the petitioner, Lordship. Electricity Act, both the petitioners have deposited the amount.
Both the
Petitioners have
entire final
deposited
assessment amount.
50% of the
No, entire amount, Lordship.
deposited the final assessment bill to the tune of so and so respectively in view of the aforesaid development.
Twenty-three.
You are 305A and 323.
23.
No. This is anticipatory bail application. You are 305A and 305E, which is akin to 379. Now, it was alleged that 50 cylinders were stolen, which was kept by the de facto complainant in a place. Now, my lord, few of the accused person, my lord, has been arrested and recovery has been done from them.
Antecedents?
No, my lord.
What no? How do you know?
There is no mention in the memo.
So find out.
In the meantime, may I go and meet because police.
No. Criminal antecedents be placed on record Tuesday.
Obliged.
Oh, क्या करता है इंडस्ट्रियल ये लेगा सिलेंडर क्या
All 5 years.
You are with
Lord, in item 25, Lord, 8 years.
25, 26,
And your Lordship
27.
has been pleased to enlarge others on bail, Lord. These are the orders.
25 my lord,
এক অর্ডার করে দাও না এক অর্ডার করে দাও
Yeah. Kindly একটু দিয়ে দেবেন একটা দিন আমাকে একটা দিয়ে দিন আমাকে থ্যাংক ইউ
AB 21
much obliged.
Same order as 25. Same order. Yesterday I was with
7, 26 has been allowed. 25, 27. All the allowed. 26 has been passed earlier. 27, 6 order में दिया 27. Much obliged.
Yes, next matter.
For the respondent writ petitioner, I preferred the writ petitioner for challenging the disciplinary proceeding. The punishment order was modified. From that order, they have preferred an appeal.
I am the applicant. I have challenged the order, Your Lordship. Lordship, regarding the order, Your Lordship, the writ court has molded the penalty passed by the Lordship disciplinary authority, Your Lordship. Lordship, here, Your Lordship, there are some points, Your Lordship, regarding molding and or decreasing and or some time. If that points consist, Your Lordship, where your lordship, here, your lordship, if in the proceeding, your lordship, any laches, suppose, lordship, I have issued charge sheet.
You are absolutely right. A writ court is not an appellate court. It cannot substitute its discretion for the disciplinary authority. But if a punishment is disproportionate, too harsh, and not in consonance with the nature of the alleged misconduct proved, then the court has a limited.
Lordship, if
what was the punishment?
If it is found,
what was the punishment?
Lordship, decreasing to increment, decreasing.
Huh?
Decreasing to increment.
Reduction of basic pay by 2 stages. That was
Nothing,
the initial punishment.
Not
The writ
major
court
punishment,
modified
your
it to
lord,
reduction of basic pay by 1 stage.
What is
2 increment with
only 2 is given.
Honorable single judge made it 1.
Only
that
why
is
are you appealing against this, sir?
Lordship, regarding the
Is this a litigation policy that you will? We would have understood that a dismissed employee has been reinstated with some punishment, so you don't want reinstatement. But you have it is a major penalty as per your rules.
This is minor penalty, your
It's
lord.
a minor penalty, no cumulative effect also. Nothing, sir, nothing.
After they have retired, I have got all the retirement benefit.
What is there?
Just this
Entire
one increment
benefits
makes-
have been received, your lordship, at the time of retirement.
Don't harass this employee any further.
Lordship, this is not the harassing of the employee. This is at the rule, your lordship.
Was that the proposed penalty or the penalty prescribed by the first court is contrary to rules? Could not have been.
Lordship, I'm coming to that point, your lordship. Page number 151 of the my ST application, your lordship.
देखो
Lordship, paragraph number 25, your lordship.
Yes.
Since this court has passed the charge number 2 as against the writ petitioner, the quantum of punishment sustained is required to be altered, and in this regard, the appropriate authority would be disciplinary authority who may impose an alternative punishment in terms of Regulation F of the Central Bank of India. This, your lordship, it appears of this court that if an order is passed directing the disciplinary authority to impose an alternative penalty, that would be in justice to prevent writ petitioner, since that would again lengthen the litigation, especially when the present writ petitioner has superannuated long back. Lordship, the petitioner has superannuated since in the 31st May 2015, your lordship, and thereafter he has received the entire retirement benefits, your lordship. And after receiving the entire retirement benefits, after 1.5 years, the petitioner filed a writ petition, your lordship. This is the settled law, your lordship. When the entire
Mr. Counsel, you are not aggrieved by the quashing of charge 2.
Lordship.
What was charge 2?
Charge 2, your lordship.
Have you challenged the quashing of charge 2 also?
Lordship, I am the implied bank, your lordship.
So naturally, you are aggrieved. Listen, the judgment has 2 stages.
Lordship.
It has quashed one of the charges.
Lordship.
And thereby, the single judge was of the view there should be again a reconsideration of the penalty. You say that reconsideration ought to have been remitted to the authority and not decided by the judge himself. That is a good point. We understand that.
One thing, your lordship, if the Honorable Court, your lordship, finds any irregularity, then the Honorable Court direct the disciplinary authority to reconsider the view.
Send it back for reconsideration instead of imposing.
Reconsider the view.
Already send it back for reconsideration within a time frame.
So he has retired from service.
No difficulty.
Now,
whatever was the penalty, the penalty has to be reconsidered and scaled down. We will say should be reconsidered and scaled down in view of the quashment of charge 2.
That is what the Honorable Single Judge has done.
That
Honorable Single Judge has held that yes, you cannot proceed with charge number 2. That is why I'm quashing charge number 2 and I am lowering the punishment. I'm lowering.
Charge number 2 is quashed. And since the penalty was in respect of finding of guilt on two heads, single judge come to paragraph 25. Was of the view that the penalty should be altered and the alteration should be first decided by the authority itself in terms of regulation 4F. Instead of remanding it because it may cause further prolixity, the judge exercised his own discretion. What we feel is there the judge may not have exercised discretion. On the other hand, could have relegated it to the authority and fixed a time frame to take a decision to scale down the penalty in light of the quashment of Article 2 of the Church. That is what is being agreed. He is not seriously the quashment of Article 2. So we can do that and we can give a time frame for disposal.
It can also be done, and your lordship will kindly
We'll do that.
appreciate that this honorable court has the
Sir,
power to do
let
that.
us make a hiatus on this. We will make it clear that there should be a scaling down. We may agree to your proposal, but we will make it clear that the penalty should not be kept as it is, but it should be reduced.
Lordship. Well, the same in the inquiry proceeding, your lordship. My submission, your lordship. In the inquiry proceeding, charge number 1, charge number 2 has been proved. Your lordship, in the previous issue, your lordship, the petitioner, your lordship, defended regarding the inquiry proceeding. Submissions, their reply. All the replies has been considered. And after considering the entire facts, your lordship, it is found that there is some misconduct. And due to that misconduct, your lordship, that the authority has been passed the punishment, your lordship. So, your lordship, if your lordship finds that some irregularities are there, from that stage, lordship, I am ready to complete. But that findings has not been done by the read court, your lordship.
Lordship will kindly take paragraph 16 of the order under appeal. Why charge number 2 was quashed?
Yes, that is what we are saying.
I was never given any opportunity to reply to the charge.
Yes, has been given. Lordship, kindly come.
Paragraph 16 and 17.
We were asking you that question, that please address us on charge 2.
Lordship, charge 2, I'm submitting, your lordship. Lordship, in page number 72, your lordship.
Come to paragraph 16 and 17.
Lordship. Lordship. The memo, this the respondent bank whereunder explained the petition was thought Lordship this point should be.
Yes.
Lordship.
Now say that why this is wrong.
Lordship. Lordship, regarding page number 72, Your Lordship, kindly come to page number 72 of my ST application, Your Lord.
Yes.
Lordship, page number 72, charge number 2, Your Lordship. CCAC Govindo Store, proprietor Dilip 1. Lordship, charge on 2nd June 2025, 3 Jyotirmay Sardar sanctioned one cash credit limit to the tune of rupees 15 lakhs to Govinda Store, proprietor Dilip Banik, for trading in wholesale business of sorting and shooting without complying credit report to establish the credential of the borrower. Sri Sardar did not conduct any inquiry from the local market or other sources. A status report from the previous banker of the borrower, Bank of Baroda, was not obtained. Guidelines of loan policy were not observed by Sri Sardar. Appraisal recommendations and sections of the loan personnel were carried out by Sri Sardar singly. There was no proper operation in the account. Sri Sardar did not make proper due diligence and monitoring of the account. Latest financial statement of the borrower account was not obtained for periodical review of the account. Periodical review of the account was not done. This is resulted to account being NPA due to these negligence act. Sri Sardar has put bank's fund to risk to the tune of present outstanding balance of rupees this. Lordship, this is charge number 2, and they have replied of this charge number 2 also. Page number 77, Your Lordship. Page number 77, charge number 2. Lordship, question has been arises in charge number 2 that the report has not been taken by the previous bank.
The memo is however what are the alleged action of credit in favor of Govinda. So it says, your memo charge. It's a different. It appears the present requisition was served with a memo. The explanation was served. There's a preliminary inquiry. The preliminary inquiry, even if it was not included. So the memo asking for his reply. Let us see what is the reply to the charge. Page 77. Yes, Govindo Stores.
Govindo's. And thereafter, reply has been made.
Can you indicate to us where is the memo dated 31/10/11?
Lordship, memo.
Page 59. Page 59 of the stay application.
This memo preceded the framing of charge. So preliminary inquiry, this Govindo's alleged irregularity was not indicated. But that is not going to affect the charge.
So one thing, before even framing this memo, there is a policy, a staff accountability policy. After a report is received by the authority that there is certain there might be certain discrepancy in granting loan.
Accountability policy, etc., are steps leading to the framing of charge. If there is an omission of a particular account in the preliminary inquiry, which is included in the charge, but effective opportunity to respond to the charge is given in the course of the inquiry, the failure to indicate that account in the preliminary inquiry, will it render the entire disciplinary proceeding invalid?
No.
Then
that it will not.
Then that is the ground on which the judge has gone.
Yes.
See the judge's logic. Judge's logic is the preliminary inquiry memo preceding the charge does not reflect Govindo Store's account. or any alleged irregularity. Point taken. When the charge was laid, the charge included that also. Maybe later on they had found, and instead of having piecemeal inquiry, they added that to the
Charge sheet.
other heads of charges and gave opportunity to the officer to respond to it. The officer duly responded to it and was taken into consideration, and findings were recorded. In this situation, the non-adding of the charge in the earlier preliminary inquiry, does it render the disciplinary proceeding wholly without jurisdiction or in breach of principle? That's the question.
Now, as per the staff accountability policy, first a memo should be issued. This is that memo. Now, the staff accountability policy says that after the memo is issued, an opportunity will be given to me to reply to that memo. And after receiving the reply, if the disciplinary authority is not satisfied, they will issue the charge
That
sheet.
is the preliminary
They
inquiry.
will issue the charge sheet. So first, they has to be satisfied that yes, we are ready to, we will proceed against him.
All right.
If they do not
All
come
right,
to a
we have
satisfaction,
understood.
initial satisfaction, how can they issue the charge sheet?
3 heads में preliminary inquiry हुआ था. Then when they are proceeding to the charge, they found the 4th charge and put it into the charge sheet instead of getting another preliminary inquiry. And in the charge sheet, effective.
Which was issued in 2011.
Hmm.
This charge was not there.
No.
So he was not given an opportunity to respond.
He was given an opportunity during disciplinary proceeding. What happens is this memo matures into a disciplinary proceeding. Now, you could have dropped this independently. What do? Instead of doing that, since they have already culminated in the issuance of the charge sheet in respect of 3 head to 1 head, they proceeded to add this as charge 2. He does not take any objection. He replies to the charge. And the reply is at page 77. The reply is considered on merits and is held against him. In this situation, can we turn the hand of the clock back and say that there was a breach of natural justice because preliminary memo has not been issued in respect of one of the heads of charge in the disciplinary proceeding? It's not a case where there was no inquiry, preliminary inquiry at all. Please show us the accountability policy memos. Is there a part of the records?
No, that is not part of the record.
We are not necessary. We are disposing of, we are allowing the
sending it back.
What?
Reminding it back to the authority.
Dismissing your writ petition.
Lashmi, kindly allow me to place the staff accountability policy.
All right. Another day. He has made out a case. Please understand one thing. Preliminary inquiry is not the disciplinary proceeding. It is a preparatory step to a disciplinary proceeding. It is not so sacrosanct in relation to the rights of an employee to answer the charge. Until and unless you show it's a case of malafide. Why we don't, at least subject to hearing you, consider it as a case of malafide is there was a preliminary inquiry. In the preliminary inquiry, the materials in respect of charge 1 was there. Maybe due to inadvertence or otherwise, charge 2 had not been placed. So it is not a case that you were not going for an disciplinary proceeding. At the stage when they are framing the charge, maybe it came to light and charge 2 was also added. Question is, let us say they did not add charge 2. What would have happened? A further prolixity and another preliminary inquiry which may or may not have added in the charge. Now that may or may not, did it prejudice you? In our understanding, prima facie, no. Because the charge was fully read out, you responded to the charge, and evidence was laid, findings were recorded. Until unless perversity, no question in judicial review to be.
Only, answer Lordship very briefly, only one thing, the Lordship will...
Wait, hasty काम नहीं हुआ है.
Article of charge they have given.
Articles of charge they have given. First article में preliminary inquiry हुआ था. Second में preliminary नहीं हुआ था for reasons best known to the authority. Maybe in order to maybe due to inadvertence and to avoid prolixity, they added the second charge in the charge sheet, in the heads of charge, articles of charge. तब ये इंक्वायरी हुआ, फुल फ्लेजेड इंक्वायरी के बाद फाइंडिंग हुआ, तो वो प्रिलिमिनरी इंक्वायरी का irregularity cannot be a ground to impact the irregularity of the charge. They followed you. Why did you start with the punishment? You should have started with charge. All right, we'll keep it on another day.
I'll bring the staff accountability
Yesterday,
policy.
the proceedings of the operation of the order details because
What?
I have filed a contempt.
All right, he
Filed-
will not take steps. He assures us.
Lordship,
I'll
steps will
inform,
not-
I'll place this order.
He will say that heard Mr. Name,
Jha,
Mr. Jha, heard Mr. Jha for the bank. Mr. Jha submits. The respondent writ petitioner had ample opportunity. Respondent writ petitioner was fully aware of the nature and import of charge 2 and had ample opportunity to respond thereto. He had not been prejudiced in the proceeding. Mr.
Pratik Majumdar.
Mojumdar,
Appearing for the writ petition.
for writ petitioner respondent, seeks time to
File the staff accountability policy.
seeks time to make submissions. Matter is fixed for hearing on, let us say,
Next Friday.
seventh.
Seventh.
Seventh. He also assures the court that he shall not proceed with the contempt proceeding in the meantime.
Lordship, may I submit one thing, Your Lordship, permit me. Lordship, regarding contempt proceeding, Your Lordship, contempt of this court has already issued passed an order directing me to recalculate the same and to submit, and there, Lordship, and thereafter, why the rule shall not
Further orders be passed in the contempt proceeding being so and so. He assures the court that he shall not proceed. No further orders shall be passed in the contempt.
Till disposal of the appeal.
Till disposal of it.
No.
Pendency of an appeal, generally, honorable judges will not.
I have humbly requested Your Lordship.
Until and unless you have troubled the judge so much that he thinks otherwise.
Because Lordship says that why not the rule has been issued against you?
Yes. Substantially हुआ.
Okay.
That's a wrong observation of the
29.
Milord.
Wrong. ये जहाँ साहब को तो हम बोल रहे थे पनिशमेंट के ऊपर है या चार्ज के ऊपर है, चार्ज के ऊपर है.
I am on for the alleged contempt Soumen Shekhar Ghosh Milord in the year to 23rd November 2015. The court on its own motion has taken this contempt application and debarred Soumen Shekhar Ghosh from practice, Milord. Milord, the Bar Council has not taken any step till date, Milord, but he is.
Let Mr. Soumen Shekhar Ghosh file an affidavit expressing complaint.
Milord, he is now completely fit, Milord.
Completely fit?
Yes, Milord.
What do you mean to say completely
Milord, here the Honorable Court observed about his mental depression. Milord, last prescription, he is.
All this will not do, sir. File supplementary affidavit.
Milord,
Alleged
Milord, in the
contemptor is at
meantime-
liberty to file supplementary affidavit placing on record subsequent development.
Milord, in the meantime, if he was
Nothing,
allowed.
Nothing, sir. adjourned 4 weeks. First you file it, place on record that he is fit, then we will consider. All right. Otherwise, again, the same thing. We don't want to embarrass your client also. Yes, next matter. Sitara. Sitara was fixed on another date.
The appeal. This is appeal.
This is
The
what?
This is the contempt.
All right. Contempt will consider after the appeal. After the appeal along with the appeal will consider the contempt, right? Contempt cannot be preceding the appeal.
No, I have.
What I have?
But I have nothing to say on this.
You are the contempt now.
Yes, but we have filed an affidavit explaining our position. Mullah.
We will see. Mr. Shahrai, argue the appeal because Mr. Bollan Bandyopadhyay said that he will take 2 minutes to get this entire appeal to dismissed. 2 minutes. 2 minutes. He will get it dismissed. All right. So be ready for that. When is Mr. Bandyopadhyay available? Next Friday.
Mullah has fixed it on 7th of March already. The
7th
appeal.
of March. But 7th of March, you have to be quick. Really 2 minutes because this bench may not.
But that is for the private respondent. Mullah, we'll argue on behalf of the state.
First, he will argue first.
For the appellant.
How? You will take 2 weeks. Mr. Bandyopadhyay will take 2 minutes seriously.
And Junior Bandyopadhyay?
Junior Bandyopadhyay is between you and Senior Bandyopadhyay.
I shall take.
The problem on 7th, Mr. is we'll have to rise early. All right, we'll begin the hearing and then keep it again.
Let it be started.
Because
The
Mr.
following
Bandyopadhyay-
Friday is not available, so we'll get a breather of a fortnight.
7th of Bhopal jana. Judicial Academy heads meeting.
Following Friday is the holy.
Or 15 or 12:30. I'll keep it at
ছাত্র স্যাক্রিফাইস করবো দিলে ছাত্র দিলে তোমার বাড়ির কাছে হবে আমারও বাড়ির কাছে হবে গড়িয়ে ফেলবে হ্যাঁ গড়িয়ে ফেলবে না হেঁটে যাবো গড়িয়ে ফেলবে
হ্যাঁ আচ্ছা ছেলেটা
3:15 applied for 30. It was good. I could have I used to take the 7 PM flight. Now 3:15 upwards to 7 o'clock. I can't beat that.
এটাকে ডিস্ট্রিক্ট করে অ্যাপিলটা 7 তারিখে 14 তারিখে ছুটি আছে ওরা যা হবে হবে তারপর
See by the time
রেডি হওয়ার টাইম লাগবে
and I get down it is about 6:45 and the counter closes by 7. If you finish over there.
সেদিন ওরা রিপোর্ট দিয়েছে তাদের কি হয়েছে রিপোর্ট দিয়েছে
I have to rise by 3:30. Huh? We keep this list along with so and so. And 7th, you begin the arguments.
So far the appeal is concerned.
Appeals. I think, what do you propose? Appeals should be addressed first, right? Appeals should be addressed first, Mr. Bandyopadhyay.
Contempts are unrelated, Mullah. Contempt will take its own course. Either we are in contempt or we are not.
Only one line, my lord, at admitted position at 10:45 PM. My cards have been detected.
After the order is
Everything.
passed.
No, just before the earlier date. 10:45 PM. My card
Not detect, not detect.
Can be.
Detect.
Technically not contempt. Technically not.
I shall show to you. I shall.
This is
Approved at 10.
Junior Bandyopadhyay is very intelligent.
I know.
He is very intelligent.
Very intelligent.
12 minutes.
1.5 years. So, my lord, when the authorities saw that they have the disciplinary dismissed, but they were very proactive.
We are not making any comment. We may not appreciate your hastiness. However, whether you are in contempt or not is a technical issue. If there was no lease, no stay, Mr.
Now, there are other issues. So far contempt is concerned. I shall show to your lordship.
That you have to show.
Proposal to dealing 15 dealers. Since I have filed case, 30 dealers detected.
Can.
No.
Subsequent.
Beyond the scope of
Scope of
approval, proposal,
Does not. Is it amounting to contempt?
No, I'm not saying contempt.
Sir, we
Conduct.
are,
I'm saying, sir, conduct.
as Mr. Shishantu Bandyopadhyay indicated, we are in the limited prism of contempt.
Let the appeal be hard
We
first.
see the contempt and we see that there is no breach of an order. Then hastiness or otherwise is a different thing. The detacking may be unfair, but not contemptuous. There's
What-
a difference
what-
between an act being contemptuous, act being unfair. Is the unfair authority trying to overreach? That is not civil contempt.
This is their case. 1045 is their case.
Yes, that is
Our case is different.
So you have to present your case. This we will consider with, but let us look into Setara Bibi in the
Shining, my lord.
in the appeal, and finish it off. Thank you. Along with your appeal.
MAT 1543.
MAT one.
Bunch.
1543 and
No, no,
1546.
bunch. এই দুটো।
1543.
Just give the lead number.
1543.
No, there is a bunch of matters for the.
1543
Just give the
of
lead
2024.
number. MAT 1543.
আমি একটা কপি দিই।
Bas.
না, না, এগুলো সব
Thank you.
আচ্ছা বলছে লিড ম্যাটার নাম্বারটা দিতে
1540 সেটারও তো।
I think we should release these. They're unnecessarily burdening us.
I shall not take half an hour, my lord.
Only half an hour.
Half an hour.
Well, there are
And 2
another
minutes. Half an
entire
hour, 2
bunch of
minutes.
appeals released by Mala Justice Division Bench Procedural by Mala Justice Mantham. Another huge bunch.
If your lordship gives my lord 1 to 30 minutes, there must be concluded. তাই তো বলো?
30 each. 30.
Then you have got the other one.
30 each it will take.
That,
There are both my points to agitate.
You and Sagor Bandyopadhyay. That matter also.
That matter. After that,
Yes.
after this one.
After this one.
Appeal number.
And then there's another big matter of there's in the corporation.
We are not. We are not that matter.
No, unfortunately, you have not penetrated
But
corporation.
my lord, if I may suggest this, my lord, if I may suggest this, my lord, it can be faster if Mr. Shahare can share his notes, my lord. At least the judgments I can come prepared. If occasions so arise, I can deal with it, my lord. Arguments are already, my lord, there because the case is, my lord, it's in continuation. Only the cases, if he wants to cite anything new, because whatever case is cited for the honorable senior, I have distinguished.
Not possible, my lord.
Look at his head.
Let I start that.
All right.
এটাতে কোনো এক্সেপশন দিয়েছে
না,
দেবেন
exception দিয়েছি আমরা।
31, 7.
30,
31, 6.
ওই 16টা ম্যাটার
সাহেব বসবেন।
Wait.
No other job, my lord.
No other job.
In courtroom. But yesterday I proposed to a honorable judge, retired, that court hour
Item 1.
My lord, I'm from the petitioner.
Next.
Item 2.
Petitioner submits that she is the wife of the deceased. Deceased had gone missing in 2000 on 19/7/2023. She reported the matter to police. Subsequently, it was found he has committed suicide. Her mother-in-law falsely implicated her in the instant case, alleging she had an illicit relation with one Amitendra Roy, and the deceased committed suicide and had misbehaved with the deceased. Full stop. As a result, he committed suicide. It is pleaded that the uncontroverted allegations do not disclose ingredient of the offense of ingredient of the offense of abetment to suicide. I have considered the materials on record. It is alleged petitioner is the wife of the deceased. It is alleged she had an illicit affair with co-accused Amitendra Roy over this issue. There was difference between the couple, whether illicit relation between the petitioner and co-accused per se would couple. As a result, her husband committed suicide. There is nothing committed suicide. Prima facie illicit relation of a spouse per se may not tantamount to abetment to suicide. Petitioner has made out an arguable case in her favor. Proceedings stayed 4 weeks 6 weeks. এটা পিটিশন উল্টো করো পিটিশনার এটা অমৃতেন্দু করেছে ওই is alleged to be the paramour of the wife of the deceased. হ্যাঁ অমৃতেন্দ্র উল্টো হয়ে যাবে on missing he has been falsely implicated. ঠিক আছে whether illicit relation with the wife of the deceased would constitute abetment. Prima facie do not constitute abetment, so answer just wife the husband. Next.
My lord, item number 3, I'm preparing for the petitioner. I'm being led by Mr. Arun Kumar Maiti. My lord, this impugned Raiganj PS case number 1343, which has been lodged on the basis of a complaint made under 156(3) of the CRPC, is a concocted and fabricated one.
Is a counter case to a allegation of cruelty to the wife.
Yes, my lord. Which was made
Petitioner number 1.
Petitioner number 1.
All right. Petitioner number 1 is the wife of opposite party number 2. She was subjected to cruelty and lodged and has instituted a criminal case under 498 capital A IPC against opposite party number 2. In retaliation, the impugned criminal proceeding has been instituted. In view of the aforesaid submission, we are of the opinion petitioner has made out an arguable case for quashing on the ground of malafides. Stay 6 weeks, service 4 weeks, service in the meantime 4 weeks contested application. Next.
Well, I'm appealing for the petitioner.
Yes.
Well, kindly come to page 33 of my application, my lord. Well, the third paragraph on further investigation. Well, the first paragraph relates to the present petitioners are the mother-in-law, father-in-law, and the sister-in-law. First paragraph relates to the arrest of the husband. Second paragraph, the next further investigation. Third last paragraph. On being further investigation, it revealed that the parents of Rahul Sharma, that is Ajit Sharma, Suman Sharma, live in India, and his sister Brinda lived in Singapore for study, while the complainant lived at Rajasthan and for a few days in Nepal along with her in-laws. Then she was tortured by her in-laws. After a few days of their marriage, Rahul Sharma and Shreya Sharma, they both left India for Sweden for Rahul's job after their honeymoon. While they were living in Sweden, the complainant became pregnant. While Rahul Sharma acquainted with his wife, pregnancy, he unkindly pressurized Shreya to abort the child. He would not stay together. Subsequently,
petitioners submit they are the in-laws of the victim housewife. Petitioner number 3 is the sister-in-law and used to study in Singapore. Full stop. The couple resided at apart from a few days after marriage, couple resided in Sweden. Allegations of torture leveled against them are patently absurd. They pray for quashing. We have considered the materials on record. Petitioner was married to co-accused Rahul Sharma after after marriage. She stayed with her in-laws for a few days, though it is alleged thereafter she left for Sweden, where it is alleged her husband tortured her and even forced her to abort. Primary allegations are leveled against the husband. No contemporaneous complaint with regard to torture. During the first few days, she shared matrimonial life with the petitioners is collected during investigation. Possibility of false implication of the in-laws, possibility of false implication of all family members of the husband due to matrimonial dispute cannot be ruled out. Accordingly, we are of the opinion petitioners have made out an arguable case for quashing in their favor. Stay of proceedings so far as petitioner is concerned. Proceeding against Raut Sharma shall continue. 4 weeks, 6 weeks, 4 weeks.
Bye.
My blood, I appear for the petitioner in this case. This is blood, I am praying for quashing of a complaint filed under section 12, section 18, section 19, and section 22 of the Protection of Women from Domestic Violence Act. This case has been filed as a counter case filed by the mother-in-law against the daughter-in-law. Now, the daughter-in-law files a complaint against the mother-in-law, the brother-in-law, and the sister-in-law. And blood, I draw your lordship's kind attention to
This
page
is filed by mother-in-law against daughter-in-law.
First case was filed, and this has been filed as a counter. There is a property dispute with regard to
Whatever. Both the cases will be tried together. Petitioner contends she is the daughter-in-law. Petitioner contends she is the
mother-in-law,
Acha.
brother-in-law, and
opposite party number 2 is the petitioner's content. Opposite party number 2 is the daughter-in-law of petitioner number 1. Petitioner number 2 and 3 are the
brother-in-law and the
sister-in-law and
sister-in-law
and sister-in-law of opposite party number 2. Petitioner number 1 had instituted a proceeding under section 12 of the Protection of Women against Domestic Violence Act against opposite party number 2. And there is a family dispute. Petitioner number 1 had instituted so and so. In retaliation, the present proceeding has been instituted. Full stop. I have considered the materials on record. Uncontroverted allegations in the admittedly, there is a domestic relationship between the parties. Full stop. Petitioner number 1 alleges domestic violence against her at the behest of opposite party number 1 and has instituted similar proceedings under the Protection of Women from Domestic Violence Act. On the other hand, opposite party number 2 alleges domestic violence at the behest of the petitioners and has instituted the impugned proceeding. Correctness or otherwise of the allegations in both the proceedings are matters of evidence which require to be thrashed out in the course of trial. Hence, I do not find any hence, I am not inclined to interdict the proceedings at the behest of opposite party number 2 on the mere ground that an earlier proceeding has been instituted against her at behest of petitioner number 1. However, it shall be open to the parties to pray before the jurisdictional magistrate that both the proceedings be tried one after another and tried one after another, full stop, so that there is no conflict of decisions. Tried by the same magistrate one after another to avoid conflict of decision. With this observation, application disposed of. These two proceedings pending before the same court.
Pending before the same court, yes.
First. Next.
6.
6.
So there's a delay of about 9 days against an order affirming conviction by the learned appellate court in a 138 proceedings, my lord. My lord, the primary defense was...
How much is the amount?
My lord, amount is 8.5 lakhs. Check amount, my lord, is 8.5 lakhs.
What is the
defense, my lord?
Amount compensation
My lord, 15 lakhs is the compensation. Check amount is 8.5.
Deposit 20% of 15 lakhs. All right, there's a section 5, no?
No, there's a section 5.
Copy of the application be under conversion delay be served upon opposite party through registered speed post. Matter will appear 2 weeks hence after the service be filed.
Okay.
Next.
7. My lord, it's become infructuous, my lord.
Dismissed, not pressed. Next.
8.
That for the petitioner, my lord, there is a condonation of delay of 180 days, my lord, and we have already filed an application. Kindly condone the delay and fix the next date.
What is why condemnation of delay? 156(3) was rejected. Cognizance was taken. Where is the impugned order? All right, application for condonation of delay be served upon opposite parties through registered speed post. Matter will appear 2 weeks hence. Next.
9.
Application, my lord, developer constructed the building. The owner, my lord, requested to the developer that his allocation also kindly sell out to the prospective purchasers. My lord. The developer agreed.
So 138.
No, my lord. What proceeding, my lord? Thereafter, developer agreed to sell out the allocation of the, my lord, owner. Or for the purpose of, my lord, he reposed security check, page number 91. Thereafter, the condition that the total amount of the allocation of the petition is 3 crore 53 lakhs 52,000. Out of that, 2 crore 26 lakhs 76,000 already been paid. The rest amount, the allocation not sold out till date, my lord. My humble submission before this owner that when it will be, my lord, sell out, otherwise you take back the allocation.
That you make your argument before
No,
trial judge.
I
for quashing of proceedings.
No, my lord, it is a security check, my lord, mentioned in this petition, my lord. Kindly see security check. Page number 91, my lord, para 7.
Petitioner prays for quashing of proceeding under section 138 of the Negotiable Instruments Act. He contends that he had entered into a development agreement with the complainant opposite party. In terms of the development agreement, security checks were handed over to the complainant, to the said complainant opposite party.
That after selling out, the payment will be made. And not sell, my lord. Some portion not still now, not sell, my lord. If the owners
terms of the
unregistered development agreement, page number 88. And para 7, my lord, security check. This check was not, my lord, dishonored, my lord, the security check. Subsequent, they admitted that the some portion not sold out, thereafter some another check also, my lord, issued by the developer. So let us, my lord, serve the notice, my lord, he come.
way.
Lord, kindly see the page number, my lord, 29. 3 crore 53 lakhs. I mean the claim, my lord, kindly see the complaint, 1 crore 26 lakhs. My lord, when, my lord, some portion already been sold out, I cleared the amount, my lord. Out of 3 crore 53 lakhs, rest amount 1 crore 26 lakhs.
As per the complaint, the amount due and payable to the complainant opposite party is rupees 3 crore 56 lakh 52,000, and in liquidation of the said liability, 3 checks totaling to 1 lakh and in part liquidation of the said liability, 3 checks totaling to 1 crore 26 lakh 70,000 were presented for encashment but dishonored. Learned counsel argues that the the entire property has not been sold out and the liability has not crystallized. Admittedly, the checks had been issued by the petitioner accused and had been was dishonored. Notices of dishonor had also been issued. The condition precedent for attracting statutory presumption under section 139 of the Evidence of NI Act is pleaded in the petition of complaint. In these circumstances, it is open to the petitioner to rebut the said presumption and satisfy and rebut the said presumption and establish that there was no legally enforceable debt or liability payable by him. No case for interference is made out. It is open. The magistrate is directed to dispose of the application for interim compensation at the earliest.
Maintainability point, my lord, will be considered by the lower court.
Maintainability will be
By the lower court, my lord.
Next.
10. 10, I am for the petitioner. My lord, will find the FIR at page 29. My lord, in a civil dispute, SC/ST Acts, my lord, intentionally invoked a 67-year-old person at a midnight, arrested. My lord, I even annexed the bail order. It will reflect how the investigating agency has acted as a recovery agent. And kindly seize the FIR. There is no witness, nothing, no public view. And let me mistake auto, please.
Petitioners submit the ingredients of the offences. Ingredient of the alleged offences are not disclosed. It is alleged that petitioner had entered into an it is alleged opposite party had entered into an agreement for sale with the petitioner and had paid a sum of rupees 4 lakhs.
5 lakhs.
5 lakhs. Thereafter, petitioner refused to sell the land and had abused opposite party by taking his caste name, abused by in reference to his caste. Full stop. It is contended that the uncontroverted allegation at its height disclosed breach of contractual obligation, and there is nothing on record to show the exact words used by the petitioner or that the imputation had been made at a place within public view. In view of the aforesaid, I have considered the materials on record in light of the aforesaid submissions. Petitioner has made out an arguable case for quashing. Under such circumstances, I have considered it is trite. Mere breach of contractual obligation would not always constitute cheating. Imputation, in order to attract section 3(1)(s) of the Act of 89, the exact imputations must be stated and the same must be made in a place within public view. Petitioner has made out an arguable case in his favor. Stay 6 weeks, 4 weeks. Next.
11. I have asked for, my lord, quashing of a complaint case under sections 384, 387, 389, 506, and 504. Well, the complaint is at page 73. The lordship finds at page 74 onwards. Without wasting time, may I submit? This complaint has been filed by the other side
my lord, by suppressing material facts, so that, my lord, he escaped. এটা নিন, এটা। My lord, in respect of the same property, my lord, a deed of conveyance was made in respect of the same property in the year 2013 to some other party. Suppressing that, in 2020, my lord, a agreement for sale was executed by the complainant, my lord, in favor of me. Thereafter, my lord, he was dodgy, killing the time. 3,50,000 earnest money he has obtained from me, and he is not paying me back. That's why, my lord, he has instituted this complaint. Thereafter, I also instituted an FIR under 424 406. Charge sheet has been filed showing him as absconder.
That is the initial deposition.
Supplementary. My lord, I am filing the supplementary affidavit, my lord, annexing the charge sheet.
Charge sheet?
Charge sheet. The FIR that I have lodged there against the complainant, there, my lord, charge sheet has been filed.
We want to know what did you say in the WhatsApp?
Yes.
We want to see annexure B.
Oh, annexure B is not here, my lord.
So we want that.
Yes.
So without that, how will we know whether there was a threat?
Sir, kindly grant me time, to file the supplementary affidavit.
Or you go and pray for discharge. Petitioner submits that. Pray for discharge before the magistrate.
Difficulty is, my lord, all the papers are not annexed.
Then why should you move an application without papers being not annexed? The basic crux of it is in
Yes,
paragraph 7.
Yes.
Annexure that you are demanding money.
Yes.
We have to see whether it was a demand of refund or it was an extortion demand.
Leave may be granted to pray for discharge.
Petitioner submits that the allegations, petitioner submit that the opposite party had dishonestly induced her to enter into a contract of sale and cheated her of the initial initial deposit made under the agreement. When she demanded refund, impugned criminal proceeding was instituted. A charge sheet has been filed, and a charge sheet has also been filed against the petitioner. A FIR was registered by the petitioner, which has ended in a charge sheet against opposite party. We have considered the materials on record. We have perused the allegations in the impugned petition of complaint in the light of attending circumstances, namely FIR registered by the petitioner against opposite party, alleging cheating, which has resulted in which has ended in a charge sheet against him. Viewed from this backdrop, petitioner has made out an arguable case that the ingredients of the offense of extortion are not evident, are wholly baseless. Stay of 6 weeks, 4 weeks, copy be served. Please, during the hearing, produce that WhatsApp, let us see. As of now, there will be rest. Next.
Well, my lord, we would like to my lord, we would like to withdraw it, my lord. Kindly do not take the trouble.
Before regular, we will find.
No.
Not.
My lord, because they are much of
Not, please. You don't like cutting and coming before me, so we.
Not at all. Not at all. Much of
Next.
13.
Pardon, my lord, I am for the petition. My lord, quashing of an FIR in a case of 498A, father-in-law and mother-in-law.
Rejected.
Father-in-law, mother-in-law, my lord, kindly seize the FIR.
Father-in-law, mother-in-law. No father-in-law, mother-in-law will be prosecuted.
My lord, no allegation against them.
No allegation.
Mother-in-law আমাকে গালিগালাজ করলো।
Enough.
সেদিনে গালিগালাজ করলো। Then next line হলো আমার শ্বশুরবাড়ির 1000 কোটি সম্পত্তি।
হাজার কোটি সম্পত্তি, naturally, that's what she said, that you are a poor girl, how do you dare to be married to this
And
man?
the next line is that আমার স্বামী আমাকে দেখে না।
হ্যাঁ, then
Kindly sees my lord the FIR.
এমনকি 28/9/22 রাতে
হুম।
মদ্য
রাতে।
অবস্থায় বাড়িতে এসে আমার স্বামী আমায় ঘুষি মারে, কারণ তার অবৈধ সম্পর্ক, আমি তাকে সম্মতি জানাইনি। এখনো পর্যন্ত আমার ঠোঁটের নিচে দাগ আছে। এমনকি আমার স্বামী আমার বাপের বাড়ি থেকে 3 লক্ষ টাকা আনতে বলেছে, প্রতিবাদ করলে মারধর করবে। 3/4/23 তারিখে শাশুড়ি আমাকে আমার বাবা মা নিয়ে গালিগালাজ করে। এই অবস্থা চল। Petitioner submit that the allegations in the impugned FIR and charge sheet are primarily directed against the husband. Allegation of abuse against allegation of abuse by petitioner number 2, mother-in-law, is vague and non-specific. Accordingly, full stop. We have considered the allegations in the impugned FIR. In the FIR, it is alleged that the husband demanded dowry and in intoxicated manner assaulted the wife. Though it is alleged, petitioner number 2, mother-in-law, abused the parents of opposite party number 2. However, the said accusation is however, the exact words used are not quoted in the FIR nor in the charge sheet. Charge sheet file.
Charge sheet not submitted.
Then what? Let the charge sheet file.
My lord, let the admitted will submit a supplementary charge sheet, my lord. Supplementary affidavit and file the charge sheet, my lord.
No.
If in the course of time, if the charge sheet is filed.
In the FIR, it is also alleged that opposite petitioner number 2 had abused the parents of opposite party number 2. Investigation is in progress. Hence, we do not wish to. Investigation is in progress. Credibility of the allegation shall be gone into in the course of investigation. Hence, we do not wish to interfere and dovetail the investigation where the petitioner accused. Accordingly, it shall be open to the petitioners to agitate their grievances, to assail the charge sheet in the event they are sent up for trial. In the event they are cited as accused therein.
Yes, my lord.
Not now. Next. You have a good case. If there is a charge sheet now, we would have stated the charge.
Yes, my lord. I
Next.
14, my lord, a bit to appear.
Yes,
my lord, the petitioners before your lordship are, my lord, the husband, father-in-law, who is a cancer patient, and mother-in-law.
Husband, father-in-law,
Mother-in-law. Now, my lord, we have come up against the charge sheet as also, my lord, quashing of proceedings. My lord,
husband we will not.
My lord, only kindly consider this. My lord, the husband is an engineer. He remains engaged for tunnel boring. Lastly, they were residing in Uttarakhand. Your lordship kindly says the FIR, there is absolutely no torture. Kindly sees the 161, my lord. Kindly, my lord. FIR is, my lord, drafted by some law clerk, but my lord, kindly sees the 161. There she could not even state what was the money, amount of the money. Just after the, my lord, FIR, thereafter, my lord, 4 pages after the FIR, my lord. Seizure list, thereafter, my lord, I have statement of complainant Shilpa Odhikari. Kindly sees. She could not even state, only says that, kindly sees, my lord. Petitioner used to, number 1 used to, my lord.
No, sir.
We
are not going to stall the proceedings so far as petition number 1 is concerned. 2 and 3, yes. Petitioners contend that.
My lord, only I, subject to your lordship's kind permission, my lord, I kindly, my lord, so far as
notice is concerned, after that, I think, my lord, this marriage can also be saved. We can try
Not
that
concerned
also.
about saving marriages.
We can try
I
that
am not
also.
concerned.
Because he is interested in.
I am not
My
concerned.
lord,
You
my
are
lord.
at liberty. Withdraw the application and pray for
No, my lord,
mediation.
let it be issued first, thereafter.
Why should we issue? We are not using our forum for mediation.
My lord,
All
my lord.
petitions are not filed for mediation.
No, my lord, she does not, there is absolutely no allegation against.
We are not agreeing with you that there is.
My
no
lord, my lord,
all
kindly,
right?
kindly in respect of 2 and.
Yes.
My lord. When-
Petitioners submit that the uncontroverted allegations do not disclose a case of cruelty. We have considered the materials on record. Victim, opposite party wife was married to petitioner number 1 on 27/1/2023. At the time of marriage, dowry was paid, dowry was given, full stop. Couple of days, the relation was good. Thereafter, the petitioners misbehaved with her on the ground that she had a stutter. After some days, the couple started residing at where was the place?
My lord, they initially went to Punjab.
At the husband's place of work. Petition number 1, husband's place of work. Petition number 1 subjected her to torture. However, the allegations against petition number 2 and 3 in respect of abetment are general and superficial. Hence, we are of the opinion a prima facie case for quashing in favor of petition number 2 and 3 is made out. Proceedings stayed for 2 and 3 6 weeks. Proceeding shall continue against petition number 1 4 weeks service. পুরোটা দেবে হ্যাঁ accordingly দেবে.
And my lord, seizure effected in the meantime.
So that proves.
Yes, my lord, charge sheet.
That proves 400.
Only would. My
That
lord.
proves 406.
My lord. Great.
Next.
15. Lordship, I brought the petition, Lordship. Lordship, against the order of rejection of a discharge application, this instant revision application has been filed. Lordship, charges are under section 498A, 406, and 365 of the Indian Penal Code. Lordship, petitioners are the father-in-law and the mother-in-law of the defector complainant. Lordship, they are aged about 78 and 76 years respectively. Lordship, on the plain and uncontroverted reading of the entire charge sheet, no case is made against me. The only allegation was that at the time of alleged crime, I was present at my house, Lordship. Lordship, I cannot be accused of kidnapping my own granddaughter, whom I kept for her own safety and security. Lordship, letter of complaint is on page 32.
We have considered the material learned counsel for the petitioner submit that the learned magistrate failed to consider that the allegations in the impugned charge sheet do not disclose ingredients of alleged offences against his clients. We have considered the materials on record, allegations against
Letter of complaint is on page 32, Lordship.
petition. We have produced the allegations in the impugned FIR and charge sheet, allegations primarily directed against the husband. Petitioners, that is the parents-in-law, were alleged to be present at the time of torture. Other allegations leveled against them are general and omnibus. Under such circumstances, we admit the petition. There shall be stay of proceedings against opposite in respect of the petitioners. The stay of proceedings in so and so far as the petitioners are concerned, for 6 weeks or until further orders. Proceeding against the other co-accused shall continue. Service 4 weeks. 4 weeks there.
Actually, the petitioners are the father-in-law and mother-in-law.
Husband is there, na?
Husband is there, and one brother-in-law is there. Lordship, against the brother-in-law, there is already a stay, Lordship.
Against the opposite party, husband shall continue. Next.
May it please the Lordship, I'm for the petition. Lord, 498A, 325. Petitioner number 1 is the husband. Petitioner number 2, my lord, is the brother-in-law who was not staying together. The mother is 74 years old. Petition number 3. And 4 is the married sister-in-law who was not residing with the. My lord, she got married in the year 2018. My lord, the allegation is 2024. My lord, the husband, the petitioner number 1, had physically assaulted her by giving a punch on her left hand. Now, my lord.
Against all the allegations, sir.
Yes, my lord.
Against all the allegations, sir. It's alleged that they participated in the assault earlier, also in that.
So far as these petitioners, with deepest respect.
All the petitioners include the husband.
Yes, she has alleged, but my lord, we are not staying together. My lord,
Husband is not staying together.
No, husband is staying, of course. Yes,
no, Mr. Ray, we are not going to interfere. We have considered the allegations in the petitioners submit that they have been falsely implicated in the case. They pray for petitioner submit. Petitioner number 1 is the husband. Petitioner number 2
is the brother-in-law.
2, 3 is the wife of brother-in-law.
4 is the wife of the brother-in-law. 3 is the mother who is 74 years old.
Petitioner number 2 is the brother-in-law, and petitioner petitioner number 4 is his wife. Petitioner number 3 is the sister-in-law of the victim of the opposite party number 2. Why? It is contended that they have been falsely implicated and pray for quashing. We have considered the allegations in the impugned FIR.
That is that written complaint, my lord.
The opposite party number 2 wife was married to petitioner number 1 on 11/10/2018 by registration. A Hindu marriage was solemnized on 18/11/2018. It is alleged at the time of marriage, as per demand of the accused, dowry was given. Thereafter, she was thereafter opposite party number 2 was subjected to physical and mental torture. She was physically assaulted on a number of occasions. On 16/4/2024, she was assaulted by the petitioners and suffered injuries. Prima facie, the allegation of assault is supported by medical papers. In light of the incriminating materials on record, and the allegation, and as the allegations implicate all the petitioners in assault, we are not inclined to interfere with the proceeding at this stage. It is open to the petitioner to agitate their grievances at the appropriate stage of the proceeding in accordance with law.
My lord, next, so far as the mother.
Nothing.
And this is my application against an order discharging the accused person who has been held to be guilty in the predicate offense of bomb blast in the NIA case and has been convicted. Now the predicate offense is the Bardhaman, my lord can recollect, the Bardhaman bomb blast case.
We don't recollect anything, sir. We only recollect what is papers before us. Beyond that,
there was a in
very poor
2000,
recollection.
in 2014 there was a bomb blast
Huh.
in the Bardhaman district,
Huh.
and after registration of
Let us see where is the discharge order.
the discharge order certified copy is there, Malad. It's order dated 29 June 2024. I will first see para 16 at internal page 4.
Absolutely reasonable order.
No, Malad, kindly allow me to place
Harassing procedure.
2-3 points. Malad.
Come to how
Yes.
the finding is wrong.
Yes.
These withdrawn
Yes.
6,59,000 between 2011 to 2014.
Correct.
Is there anything to show that this money was utilized?
Yes. It
What?
was showed that was
Apart
not
from
considered.
statement of the accused.
Yes. No, Malad, kindly come to page 64. Paragraph Roman 4.
Huh.
When the protected witnesses submitted before the London NIA court that he funded the organization of the meetings, identified, recruited, and radicalized the vulnerable youths.
You use this protected witness in your complaint?
Yes.
Did you rely on this protected
Yes.
witness?
In my supplementary complaint, this is my supplementary complaint. What I am showing, this is my supplementary complaint.
All right. Learned counsel for Enforcement Directorate submit. The judge failed to consider the statement of protected witnesses which show that petitioner had funded terrorist activity. The copy of the petition.
I've served Malad already.
Yes, sir, Malad, I am appearing on behalf of respondent.
Yeah, but then even if that is so, what is the proceeds of crime?
Now the Malad, the proceeds of crime is the 6 lakhs rupees which he
It is
withdrawn.
funded by what?
And whatever is lying is the proceeds of crime.
No, sir, that is not proceeds of crime. It can't be proceeds of crime. If someone is funding, money in his hand is not proceeds of crime.
No,
if he is receiving the funding, is proceeds of crime.
Correct. Malad, the
all right, let him argue. Let this matter appear as contested application 4 weeks. Very stretched argument. No, not proceeds of crime.
Malad, in the meantime, Malad, may I use Malad affidavit opposition? Malad?
What affidavit? Why?
Because one order, Malad, on the strength of which Malad the check was issued and they're relying the documents, the state bank statement, that those checks were used by the wife of the opposite party on the strength of an order passed by the NIA court. And it is reflecting there. The orders are reflecting there. So, Malad, as your lordship.
Let them first satisfy
As your
on
lordship.
the materials.
As your lordship.
If there is some confusion, the court will ask you to file.
As your lordship. Much.
Next.
Much. With liberty.
Malad, the matter will come up after 4 weeks
Contested application.
as contested application.
Much.
With liberty.
In this case, my lord, I am for the petitioner. My lord. The case is, my lord, the allegation, my lord, the opposite party number 1, my lord, and my lord has been throwing, my lord, stones, urines, and everything, my lord, and polluted the petitioner's house and surrounding areas, and protested them. And thereafter, my lord, his son, complainant son, assaulted me, and my lord lodged a complaint before the concerned police station. Thereafter, my lord, charge sheet was filed on, my lord, 26/9/23, page, my lord, 19-20, page 19 to 20, if your lordship, my lord. And for saving the said case, my lord, he filed the false case on 5/10/2023. Complaint was filed. I have challenged the said complaint under section, my lord, 425, 323, 506.
Petitioner submits that opposite party number 2 and his son assaulted him. As a result, he suffered injuries. He lodged FIR, which has resulted in a charge sheet. In retaliation, opposite party number has filed a false case. We have considered the materials on record in light of the aforesaid submission. Petitioner has made out an arguable case for quashing on the ground of malafide. There shall be stay of proceedings for 6 weeks, service 4 weeks.
Yes.
Thank you.
It is peruse the impugned complaint. Uncontroverted allegations in the complaint show petitioners show opposite party number 2 had entered into a contract for supply of Canadian yellow peas for rupees 26 lakhs. A sum of rupees 10 lakhs was paid in advance. However, the supply could not, due to government notification, supply could not be effected, and they were assured that the amount that a certain, they were assured that other food grain would be supplied. Uncontroverted allegations, prima facie disclosed breach of contractual obligations. Let a copy of the petition be served upon opposite party number 1 through public prosecutor, 2 through registered speed post. There shall be stay of proceedings for 6 weeks. 4 weeks. Next.
20.
20, I am for the petitioner, Lordship. Lordship, against the impugned order, appeal lies but wrongly filed.
Petition. The order is appealable. Hence, the application. What is the order? What is the order? What is the impugned order?
Lordship,
Where is the impugned?
12th July, Lordship.
Oh,
Page number. Lordship, 12th July 2024.
this is under section 23. Order under section 23 of Protection of Women from Domestic Violence Act is an appealable one. Accordingly, revision petition is not maintainable. Revision petition is dismissed as not maintainable. Certified copy be returned. After replacing the same with a photocopy, liberty to seek appropriate remedy in accordance with law if so advised. Next.
I am appealing to the petitioner, my lord, praying for my lord, quashing of proceedings under 498A 34, read with section 4 of the Dowry Prohibition Act, my lord.
Case
My
has
lord,
been compromised by and
compromised by and between the parties, my lord.
we have filed a joint compromise application. Not
All right, petitioners have amicably resolved their matrimonial dispute. They pray for quashing of the impugned proceeding which arose out of the said dispute. In light of the law declared in B.S. Joshi and Gyan Singh, we are of the opinion that the continuation of the proceeding and in view of the resolution of the matrimonial dispute, continuation of the impugned proceeding would be an abuse of process of court. Accordingly, proceeding is closed.
Let only one thing I should indicate, Millard. There were 4 accused persons. Second has died, Millard. 3 and 4, Millard, they are in sister of the Millard husband, Millard, and brother-in-law of husband. They are residing in UK, Millard. Against one of them, Millard, they had obtained bail, but subsequently, Millard, their steps were not taken. Subsequent thereto, Millard, wife has came from England, Millard, obtained bail, Millard. Only so far as the brother-in-law is concerned, Millard, of this husband, Millard, warrant of arrest is there, Millard, still now, Millard.
Warrant
I should
as a petition number 2 is died.
died, that I have annexed, Millard.
Where have you annexed?
Yes, Millard, death certificate I have annexed, Millard, page
Petitioner has
23.
died.
No, Millard, petition, Millard, accused number 2 has died, Millard.
We are not. We're before the petitioners, na?
I'm so sorry.
Warrant of arrest, if issued against warrant of arrest issued against petition number 2 and 3 against petition number 3 be recalled.
4, Millard. 3 has been, Millard.
My God.
Millard, 4, Millard.
Sir, with heaven's name, please, with folded hands, see your petition. There's no 4.
Yes, I'm so sorry, Millard.
You should be.
I'm sorry, Millard.
These live streaming is for the wonderful performance of lawyers. The efficiency they display to defend their clients. That they don't even know how many petitions, who is there.
Millard, he was accused number
Please.
4, Millard. I'm so sorry, Millard.
Let your embarrassment end, our irritation end.